All right, welcome everybody to the latest installment of the Insurance Law Workshop. A few sort of preliminary remarks because it's the beginning of the semester. Most of you have joined us before, but for any of you who haven't, what we typically do here is is put a spotlight on work that we think is interesting in the field of insurance and insurance law, very broadly construed. Um, some of it is straightforwardly work, legal work, but sometimes we have historians or sociologists or economists or political theorists join us. And the audience that we envision is similarly diverse. We're aiming to speak to academics, to students, to in-house lawyers, firm lawyers, regulators, uh, and anyone else who's interested in insurance law. If you happen to know someone or of some work that you think would be relevant and potentially something we would invite to speak here, we encourage you to send us a recommendation. And what else? So these sessions are typically recorded and then posted to our website after the fact. So just keep that in mind. That's not always the case, but that's the sort of default. And the general protocol is that the speaker will present for about half the time, about 30 minutes, sometimes a little bit longer, a little bit shorter, and then we'll preserve time after that for moderated Q&A with the audience. If you would like to ask a question, you can use the little hand raise function in Zoom. And if for some reason that's not working for you, just you can write something in the chat, but we would encourage you to ask it live rather than writing it in the chat and having us read it aloud. Um, Another thing, we're test driving this semester, providing CLE credit for those of you who attend and would like that. Um, Currently, we're only providing it in state of Connecticut. So if you need CLE credit for Connecticut, there will be a link that I'm going to post in the chat later in the session with a code, and you can fill out the form and put in the code. If that goes well, we may roll it out to other jurisdictions later this semester. Um, any other logistical things I'm missing, Peter? Okay. And my co-host, Peter Stiegelman, uh, and y'all know him. He's great. I think that's it. Anyway, so today we're very happy to welcome someone who many of you already know, Renee Henson. She's an associate professor at the University of Missouri School of Law, and she's going to be sharing with us a brilliant paper titled Artificial Intelligence, Judicial Evolution, and Insurance. And with that, I'll hand it over to Renee.
Okay, thank you, Travis. Well, I'm delighted to be here to speak today about my new piece forthcoming at BU Law Review. So new AI related liability is emerging with what I have I've adopted a term, algorithmic harm cases. So I'm working on this article, which draws heavily on GW Law's database on AI litigation, and it analyzes developing product liability lawsuits involving algorithmic tools. Now, the term algorithmic injuries or algorithmic harm or algorithmic liability, for the purposes of my article, refers to the psychological, emotional, and sometimes physical harms that are caused by interactions with AI-driven technologies. Now, these harms include, but are not limited to, in my piece or the focus of my piece, depression, anxiety, suicidal ideation, and other related harms. These injuries are increasingly litigated under product liability and negligence doctrines. And although algorithmic liability does encompass a broad range of legal harms that arise from a variety of algorithmic activity, this article does limit its focus to a discrete subset. Again, those including mental, emotional, self-inflicted injuries that are grounded in tort-based product liability. And this limitation is deliberate. I limit the scope because courts are increasingly confronting these claims in novel ways, as I discovered, suggesting a new emerging doctrinal shift, which I will discuss. Second, analyzing algorithmic harms through a narrower lens is both doctrinally and practically useful, at least within the scope of my article. And third, the sheer breadth of algorithmic harm cases makes a broader treatment of these claims in a single article, I think, a bit more challenging to manage. So I do limit things to, as I said, these product liability claims that primarily give rise to these emotional, mental, psychological injuries, while expressly limiting other types of tort actions, including libel, defamation, etc. So algorithmic harm cases are reshaping core doctrines of legal responsibility and immunity, including those that implement Section 230 of the Communications Decency Act, First Amendment, and products liability law. Now, this form of growing liability may, I argue, expose insurance gaps, as the alleged harms may fall outside of the scope of coverage that are provided by traditional existing insurance policies that we might think cover these types of harms, including commercial general liability, business owners, errors and omissions, and cyber insurance lines. Now, the first part of my paper explores this fast evolving judicial evolution related to these types of cases. Now, until recently, courts rarely allowed these types of algorithmic injury claims past the early procedural challenges phase of litigation. These were often dismissed under Section 230 immunity, First Amendment protections, or by finding that algorithms are not products for the purposes of products liability. And these defenses and claims have largely been successful up until recently. For example, in Anderson v. TikTok, the case that many of us, I'm sure, have heard about, have learned about in one way or another, involves a 10-year-old girl who unfortunately passed away after attempting the blackout challenge, a viral challenge. Plaintiff alleges that TikTok is defectively designed to addict minor users by its app's repetitive and dopamine-driven feedback loops, by encouraging minors mostly to watch, share, and attempt these viral challenges. Plaintiff claims that TikTok specifically designed these unreasonably, dangerously defective products, contending that the plaintiff does not bring this claim against TikTok as a third-party publisher of information, but instead under theories of strict liability and negligence. Now, the Eastern District of Pennsylvania granted the defendant's motion to dismiss as to all counts on Section 230 grounds initially, holding that TikTok is a publisher for the purposes of Section 230. But the Third Circuit Court of Appeals reversed, relying in large part on the U.S. Supreme Court decision Moody v. Net Choice, which held that social media firms that engage in first party, First Amendment protected speech, when they actively curate third-party content using algorithms. The Third Circuit concluded that there was no reason that TikTok's identical use of algorithms to curate content should not similarly constitute first-party speech under Section 230. The Third Circuit's decision does diverge from other appellate courts, but I argue in my piece that it does begin to signal a growing trend, and courts are beginning to allow algorithmic liability claims despite these defenses like Section 230 immunity and First Amendment protections. And I argue that there is a growing, nascent, but growing body of case law that does suggest early signs of legal disruption that will lead to the risk of exposure to a large swath of companies that might operate on the internet in certain ways. And there are other cases that I study in the piece where courts are not, at least presently, outright dismissing claims early. Another example is Character AI, Garcia versus Character AI, which revolves around a minor child who engaged in self-harm, unfortunately, and committed suicide after engaging with a chatbot. The court said that this case was not barred by Section 230 or the First Amendment. Also, there is the in re social media multi-district litigation cases, where the court has held that some tools, features are not subject to Section 230 immunity and are products. And although these trends are just emerging, and I do want to emphasize these are emerging trends, again, I argue that they introduce legal uncertainty to firms deploying algorithms that lead to emotional, psychological, or physical injuries. So this raises questions about liability and insurance. The next part of my paper discusses the symbiotic relationship between tort law and insurance law. When new forms of liability arise, insurers often do develop new products to meet the resulting coverage demands. And liability rules and insurance frameworks often work together. They work very closely together. When liability rules shift, they create legal uncertainty. And this uncertainty reveals the need for responsive insurance solutions. And substantial exposure drives demand for new insurance products. Insurers depend on the credible threat of liability to sustain demand for these products. And because courts routinely, even if sometimes indirectly, consider the availability and the scope of insurance coverage when shaping liability doctrine, the very existence of insurance does serve to amplify the impact and the reach of liability rules. Existing insurance and frameworks, however, may not yet address the distinct risks that are posed by algorithmic decision-making, which I argue underscores the need for tailored coverage solutions. Now, insurers are typically large, inertial institutions that demand substantial justification before altering course. Like firms in other risk-averse industries, insurers confront the possibility that investments in product development will not yield commensurate returns. The insurance sector, by design, prioritizes financial stability over innovation, and we expect this. Society relies on insurers to make sure that capital reserves are sufficient to satisfy claims. And so the industry often lags in addressing emerging liabilities. When combined with the speculative and contested nature of the claims arising from emotional and mental harm, this type of conservatism suggests that insurance solutions may prove unavailable precisely when they are most needed, which I would argue is now. And although we have this shifting landscape that calls for a demand for new insurance products, AI specific insurance products that would respond to this shift, the insurance industry has not yet responded, and historically it is slow to respond. There is an insurance gap with existing policies. The problem is that with most courts, they hold that emotional distress alone, especially without physical symptoms, does not qualify as a bodily injury under CGL or business owners' policies, though a minority of courts do recognize this. CGL policies sometimes do interpret bodily injury to include mental and emotional harm, but this construction can vary. And some courts have held that mental injury qualifies as bodily injury when it stems from or results in physical harm. Claims, however, that allege emotional or psychological distress, such as depression or anxiety, independent of any physical injury, might fall outside of the scope of coverage. And business owners' policies presents similar concerns. Errors and omissions policies do not typically cover bodily injury, and similarly do not tend to cover emotional injuries either. Cybersecurity is unlikely to present as a solution as well because these policies are typically designed to protect insureds from liability arising out of discrete cyber events, such as data breaches, identity theft, or the unauthorized disclosure of personal information, for example. Now, I do want to mention that silent AI coverage may be acting as a short-term solution presently. Silent coverage may arise when the relevant policy neither expressly includes or excludes coverage, or where policy language is ambiguous. However, I would posit that silent coverage presents a sister problems to those that I've mentioned here today. Although insurers may be covering some of the harms that arise in the absence of clear policy term language, this absence of assurance may still have the capacity to create uncertainty in the marketplace and potentially lead to less confidence. The existence of insurance in risky industries does generate trust. When we have insurance, there tends to be more trust. And trust generates further investment because investors understand that there are backstops in place. In addition to silent AI, there are some firms that have created affirmative AI policies. However, to my knowledge, no existing policies currently provide coverage for the algorithmic liability issues that I've addressed in this article. Existing affirmative AI policies marketed by Lloyd's and other insurers, for example, offer coverage for deviations from expected AI behavior. This might include things like hallucinations, model drift, or mechanical failures and related failures. Similarly, Google has issued an affirmative AI policy as a variant of cyber insurance coverage, which is available exclusively to its cloud customers. Additionally, Munich Re has introduced a policy that provides a performance guarantee for AI technologies. But none of these policies clearly cover the specific algorithmic injuries that are the subject of this article. Rather, they seem to target economic harms and potentially some physical harms that are caused by technical malfunctions. For instance, an affirmative AI policy could ostensibly cover injuries from autonomous vehicles if the autopilot's design deviates from engineers' original instructions, for example. But at the same time, insurers have begun to introduce AI-specific exclusions in policies. For example, Verisk recently rolled out a new CGL exclusion specifically for generative AI. And this would explicitly exclude coverage related to bodily injury, property damage, or personal and advertising injury that arises out of generative artificial intelligence. Now, I think it's important to mention that this is not just a Meta or a TikTok problem. Firms of all sizes that use algorithms to recommend content or to generate text are potentially exposed. This could mean that thousands of businesses could soon face algorithmic liability, and many would lack the resources to self-insure. Therefore, insurance would provide compensation to those harmed by these AI-enabled products and tools. Additionally, it does support ongoing innovation by safeguarding financial viability of startup small AI firms. And these firms might otherwise face bankruptcy. And so this preserves meaningful competition within the AI industry. Now, in my piece as it is written, my solution is less a legal remedy and more the advancement of a market-driven solution in response to the acute problem of ensuring the financial resilience of AI firms in the face of growing litigation. Although some AI firms are issuing these limited AI insurance policies, as I discussed, At the moment, they are limited, and they seem to cover business interruption or, like I said, AI-related malfunctions. But then again, we have just as many firms, it seems to me, issuing AI exclusions that would explicitly exclude AI-related harms. Now, just how insurance companies should create a model for the harms that I've identified, should create a policy for the harms that I've identified, I think is a separate question. It's a large and important question. And I don't spend much time discussing that and analyzing that issue in my piece, but I do talk about the fact that insurers have many ways of managing risks. So insurers routinely confront and manage risks that do defy precise calculation, as would be the case here with these emotional, psychological harms. And even policies that are supported by extensive actuarial data are inherently uncertain in nature. There are mechanisms that insurers have at their disposal to assist in pricing out policies. For example, expanding the pool of insureds to generate additional premium income, curtailing litigation costs, raising premium prices, capturing profits from policies that ultimately present lower than anticipated risks, for example, and distributing coverage across multiple carriers, among other tools that they have at their disposal. Lloyd's of London, which is the world's largest insurance marketplace, exemplifies this capacity, and I spend a bit of time discussing that in my piece. So Lloyd's specializes in what no one else typically will insure, and they cover the biggest, most unusual, and hardest to analyze types of harms. It operates in part by enabling brokers to collaborate with insurer syndicates, which divides liabilities into manageable portions. And so large catastrophic risks are divided into smaller portions and distributed across many insurers. And this allows Lloyd's to cover a multitude of injuries and harms. And even in cases of routine and well-known insurance fraud, for example, insurers respond by raising premiums and spreading costs across a broader base of policyholders. Another example of the resiliency of the insurance industry generally is COVID-19, which disrupted almost every line of coverage, and the industry is still structurally sound. Now, as a potential solution, I briefly discuss creating potentially a version of parametric insurance. Parametric insurance operates by covering damages if certain predefined triggers are met. Parametric coverage is triggered when a specified condition defined usually beforehand in the policy is triggered, and coverage is determined by an objective standard, which is the triggering event. And so to recover under such a parametric policy, the insured must generally only establish ownership of the covered property, and to demonstrate that the parametric condition was satisfied. And so this could work in an algorithmic harm setting. In a similar high risk industry, that is cyber, insurers have introduced cyber parametric insurance products. So this serves as a potential model to the algorithmic liability issues that I've described in my piece. So my first contribution in my piece is just descriptive in nature, asserting that courts are evolving in their approaches to this algorithmic liability, which leads to a lack of certainty. That uncertainty should fuel the demand for insurance among firms that would be vulnerable to litigation and potentially very large judgments that could lead to ultimate insolvency for these smaller firms. And so insurance emerges as an important tool for sustaining innovation in the AI industry. And yet, existing policies reveal gaps which leave these firms exposed to potential high risk. My next contribution is in identifying these deficiencies and arguing for an affirmative AI policy solution that might fill the gaps identified. Okay, I will stop there, and I'm happy to answer any questions and to hear any feedback and suggestions that anyone might have. Thank you.
Great, thank you. So I'll keep the queue. Again, if you'd like to join the queue, just raise your hand in the little raise hand function. And first on the queue is Dan Schwartz.
Hi. So sorry about not having my camera on. And Renee, I think this is a great paper, and I have a short contribution that response that's being published. And I'm not going to talk about that because Renee and I have already talked about it. But I do have a question. Well, two questions that actually are not within the scope of that we haven't talked about, Renee, and that sort of have come to me in between that our discussions previously of this. And so the first question I have is whether or not it's analytically right to bundle together the social media algorithmic liability that you're discussing and the chatbot liability that you're discussing. And I ask that because there actually seems to be a lot of differences in terms of the magnitude of the risk, in terms of the data about the risk, in terms of the firms that may or may not be liable. And it seems to me entirely plausible that you might imagine one type of policy covering one of those risks and a different type of policy covering the other. And to be a bit more specific about that, and this is sort of related to my second question, it's not entirely clear to me as that at least the social media algorithmic liability that you're discussing wouldn't be covered by a media liability policy. I know in the past we've talked about tech E&O policies and so forth, but I've taken a look at some media liability policy language, and they have very broad language for how they define media liability. And so really two questions there. One, are you imagining that, or are you committed to the idea that the way you've defined the risk is the way it should be insured? Or do you think there's a potential case to be made for, insuring these risks by disaggregating them between generative AI chatbots on the one hand and social media on the other? And two, how confident are you that a media liability policy wouldn't at least cover the social media, harms that you're describing, such that we don't actually need a change in policy language, that we might need a change in policy pricing given the rise of this risk?
Right. So I will start with your first question first, which I think I could see it working both ways. I could see a separate policy for social media and a separate policy for chatbots. But I think it works quite well bundled together as it is, at least in terms of, I'd be interested to hear, Daniel, your thoughts about the magnitude of the harm. I mean, it seems to me that the magnitude of the harms at issue are very similar, at least if we're just looking at the cases that I analyzed in my piece, which are, I think, good representations of what we can expect. The NRA social media cases and Garcia v. Character AI, and the harms seem very similar to me. The users generally seem very similar to me in terms of minors that are engaging with tools in ways that lead to these very distressing mental and emotional harms. And so I see a great similarity there in terms of social media causing anxiety, addiction, self-harm, and minors engaging with chatbots in ways that are leading to the exact same harms, and increasingly so as well. So we see that recent studies are showing that minors are they prefer in some cases to engage with chatbots over their actual real life friends. And they're using chatbots at increasingly high rates, more and more as friends, as sexual partners, in ways that are quite alarming, actually. So although uh, chatbot use is newer, I do see minors' use of the technology growing, but the harms to me and the magnitude of the harms seem very similar in terms of, I mean, to me, it seems that the harms are almost identical and maybe even more severe on the chatbot side of things. But I could see these working well separately too, and very easily, much more easily defined if we're contemplating separate policies. So I think that's a really great suggestion, and maybe it is right to separate these out. Um, in terms of the media policy language, I think I want to take a look at that more closely. And um, so I might circle back around and look at the media policy language more closely.
Yeah.
My understanding, at least in my research, is that it wouldn't cover the types of actions and harms that we're seeing in terms of, um, uh, for example, with the INRI social media recommendations, algorithmic recommendations of harmful content or filters, images that use filters that lead to um, negative thoughts about one's image, which leads to anxiety, etc. And so I will plan on circling back around to that media language, Daniel.
Sounds great. Just as a quick follow-up, um, to respond to the point about the extent of the harm, you're absolutely right that like at the end of the day, the harm is similar in terms of terrible psychological harm or even suicide. But where the real difference is we have no idea really the magnitude or risks about how many people are going to and start having psychological and bodily harm associated with conversations with chatbots. Like, there's not a lot of good information about AI induced psychosis from that and people, and we don't know how to. Whereas, the social media landscape, I mean, TikTok's been around for a while, the social media's been around for a long time. So, I mean the nature of the harm in any individual case, the more I mean, from an insurer's perspective, what matters is the aggregate and, the correlations and the risk mitigation measures. And so if you think about the risk, not in an individual way, but in a sort of portfolio way, they actually seem very different to me, such that, an insurer taking on one of those might be different in kind or might want to price it differently or might want to underwrite differently for one of those than the other, or might even be reluctant to cover the AI induced chatbot things because we just don't know. There's so much change right now. So
Right.
that's I guess sort of the dimension on which it seems to me like there's a pretty good argument that the two might be optimally insured via separate mechanisms. But I'll stop there. And
Yeah, no, I think that's a great point. And I agree. And it's early days, right? It is early days with the harms that we're seeing with chatbots, and certainly what we're seeing is very alarming. There's data that shows that uh, interactions in some cases can be positive, but we're certainly seeing more and more concerning cases on the chatbot side of things. But I would be very interested to see, and perhaps we just need more empirical research on both sides. What are the harms with respect to social media use, which is used, very, very broadly and for a long time, in comparison to chatbot use, and of course the research is further along with social media use, certainly. But yes, it is early days. So I agree. That's a really excellent point. Yeah, thank you, Daniel.
Great. Esserhan, you're next.
Hey, do you hear me?
Yep.
Okay. So great topic. I love the topic, but on 2 points I have questions. The first one is related to Dale. I am not sure. I think maybe I'm wrong, but I think you are using the word algorithm and then the concept of AI. Um, equivalent to each other, but they are actually very different. But maybe I am wrong. Algorithms can be autonomous, but doesn't have to be autonomous. So you can set the algorithm, but AI has to be at least semi-autonomous. So I am not sure they are the same. And then the second thing is, I think the gap that you are describing is more like an emotional harm gap than an algorithm AI gap. Because also, again, maybe I'm wrong. Because if an employee hurts a customer's feelings and gives them an emotional damage under the terms that you were describing, commercial liability policy, it's not covered also. So there is like no difference between AI hurting someone's emotions or the company with its physical employee hurts emotions of a customer. So again, I didn't give a close read. Maybe I am wrong. So that's it.
Yeah, no, yes, the term algorithm and AI are different, certainly. Yeah, in the piece, like I said, I use the term algorithmic harm, injury, liability to try to sort of couch this very broad category of harms that we're seeing. And to your second point, yes, I mean the harms are old, right? Like in terms of emotional, psychological, there's nothing new about that. But there is something new and different. I guess that's what I'm trying to capture, Esarhan, is the unique um, uh, way that these harms are coming about with these tools and how they are becoming such a problem with certainly a certain demographic, at least at this point, of of the United States, which is leading to litigation. And so the litigation is what drove the sort of exploration into the gap. It's for me, it was going to GW Law's database to see, what is actually happening on the ground with respect to AI litigation in the U.S., limiting my scope to these types of products liability claims to see what is happening, A, and B, what that might be doing to how that might be affecting exposure and risks for firms that are deploying these types of tools. So yes, I agree. Algorithm, the term is used probably loosely, and in some ways, I'm using the terms used by courts and by others in the insurance industry to try to encapsulate the tools that we are trying to wrap our hands around um, um, uh, that we see in these types of harms. So yes, thank you.
Great. Bill Goddard.
Thank you so much for this wonderful talk on such a very important topic. Appreciated this and appreciated your talking at the UConn AI panel a while back. There is a risk with AI, or whether with self-modifying AI, that one could cruelly call the ex machina risk. We have seen a remarkable number of therapy bots. And of course, it's been some years now since the National Eating Disorders Alliance had their bot go rogue and recommend dieting advice, as I recall. So it's possible that the actor is the algorithm, and the algorithm modifies itself and is a professional, is a giving professional advice, especially the therapy bots that are all out there now. That are really, I think it's early days, but there are way too many of them to not have a situation in which advice is given, professional advice, medical advice, that can actually by itself do bodily harm. It's because they're self-modifying. What mechanism of liability can we anticipate that courts will find when there is direct medical harm caused by an algorithm that's modifying itself? Sorry. Thank you.
That's a big question, Bill. I think I think there is promise in the products liability realm. I might be biased. I practice in products liability. I teach products liability. As I discussed, we see that courts are starting to treat these cases differently, and the changes in algorithms being seen as deviations in design, right? So that does lend itself fairly well to design defect under strict liability or just general negligence, products liability, causes of action. So but there are major barriers, including causation. That is a huge barrier that this paper does not address. Um, and many courts have not even gotten to that issue yet, how to deal with the issue of causation. But to answer your question, I think like I said, there is promise with products liability, and maybe certain types of products liability causes of action, maybe more specifically strict liability. I think there's great promise with potentially modifications of the abnormally dangerous activities test. I've argued that before in prior research. Um, uh, Others are arguing for changes to laws of agency, going to your point, maybe more specifically, that we should think about agency laws to deal with some of these types of harms that we're seeing, some of these types of algorithmic harms. And so, people are discussing what the best vehicle for liability is with these harms. And I think it gets much more complicated as the tools become much more sophisticated, as we know that they are. And that does raise very separate but incredibly important issues and questions related to um, control, personhood, um, all of these very, very complex and big questions that are certainly being discussed among scholars. But yes, there are a variety of approaches that certainly will be taken, I'm sure. But like I said, I like variations of certain strict liability vehicles, doctrinal vehicles that presently exist.
Thank you so much.
So I'm going to take the prerogative and add myself to the queue. So I have a kind of woolly question that I'm interested in your thoughts on as someone who's read a lot of these opinions, or however many there are. But anyway, this is a little bit more philosophical than doctrinal. So it seems to me like I get the vibe when reading some of the writing on these opinions that some of the resistance to these claims from judges, especially when we're talking about like First Amendment defenses to the claims, is kind of motivated by a desire to distinguish natural intelligence, like humans, from artificial intelligence. It's sort of like visceral revulsion to AI. And what I mean by that is like part of the reason why I know nothing about First Amendment law, but my intuition is that part of the reason why we protect speech is because there's this idea that when someone talks to you, how you respond to that speech is determined by you as an autonomous listener, right? Like you can't just like program people and tell them what to do and have them respond to it in like a mechanistic way. And so that's part of why you can't hold a speaker responsible for the way the listeners receive their speech. And so the idea, part of the rationale for finding there to be a First Amendment defense is to say, look, it's not like when people play video games that involve like shoot 'em up video games, it's not as if they're going to mechanistically then go out and actually shoot people. Like if they choose to do that, that's a decision they make. That's not something that was like forced upon them by the experience of playing the video game. And the same is true of these interactions they have with AI. And so our desire to find there to be a First Amendment defense is it's sort of motivated by a desire to distinguish us from something that would respond to external stimuli in a mechanistic way. But what's funny about that is that that creates this kind of like weird conceptual paradox because like the result is that you're treating AI speech as protected speech because you're trying to distinguish yourself from AI. But treating AI speech as protected speech suggests that the person that the, like the speaker is autonomous in some way that sort of looks human, and so it creates this like weird little contradiction that um that I anyway. So that's a very long-winded question, but the question is, does that strike you as a does that resonate with you as a sort of a description of part of the logic of some of these decisions that are inclined to find AI speech to be protected speech?
Yes, that's a really awesome question. I love these kinds of questions. As you say it, Travis, it does resonate with me, although admittedly that had not struck me before. And courts are certainly not speaking about these tools in the way that you describe, or anything that at least would suggest that they are concerned with the things that you said. But I think probably yes. I think that's probably a part of the um, resistance. I think another major part, though, and probably uh, arguably a greater part of the resistance is um, courts tend not to really understand these technologies very well, right? And so I see courts grappling with the technologies in these cases that I've read and earlier cases that I've read um, in more nuanced ways. But it does seem that courts struggle with understanding the capabilities of the technologies and also like what technologies we're talking about, what tools we are talking about, what tools are pertinent. And it seems to me that in some cases there are misunderstandings about how these tools operate and the capabilities that they presently have. But increasingly we are seeing courts really wrestle with, well, how are these tools different from video games exactly? How are these tools different from um, information that is contained within an instructional book on mushrooms, right? Like the an old products liability case. How exactly are these tools different? How do they vary? And let's sort of take a new view. So to court's credit, I am starting to see that. But to be clear, thus far, First Amendment protection or anything along the lines of First Amendment protection um, have not been for large language models, but for the first party speech of these manufacturers, the designers, right? The TikToks of the world. So their curation um, tools, like the curation, the algorithmic curation, is their first party speech, not speech bestowed upon these large language models. And I think you're right. I think it probably, I don't know when we will see that, if we will see that, because it does really go against a very strong sort of urge not to attach personhood, although not always, right? We see with corporations, but personhood, at least in a limited sense, to tools. And at the same time, um, we are seeing acknowledgement in some of these opinions that there is something distinct here. There is something different and new about minors conversing with chatbots that will encourage them to behave and engage in self-harm. Like that is something new. And prior to basically now, relatively speaking, 2022, before LLMs were widely available, speech and conversation were activities that were uniquely confined to human language, human beings, human minds, and the ways that we are able to converse, which are incredibly complex, have been limited to human beings. And so we're no longer seeing that because we are seeing and increasingly surprised at the capabilities of these AI tools that seem to have the same conversational skills and even in some cases understanding of the context of conversation. And I do think that at least in some cases with, for example, um, the TikTok case, courts are starting to sort of throw their hands up in some ways, to say, almost enough is enough. We need to do something different. And so that's a fairly muddled way of answering your question. But yes, it resonates. No, I haven't seen it explicitly sort of stated as such in these opinions. And courts are starting to really try to wade through these technologies and issues, even with their sort of lack of expertise when it comes to the specific tools at issue.
Great. Well, thank you for answering the question. Peter.
Okay, so can I try something on you that, in some sense flips your insight on its head? So it's very interesting to hear about the liability gaps. Like there's just uncertainty about what exactly somebody can be held liable for in this area. And then there's insurance gaps of what insurance is going to cover. If there is liability, what kind of liability insurance will cover. But those seem like very separate problems, and maybe they work in opposite directions. So it seems to me that if you make a strong case that people facing risks who don't have insurance are going to be more careful. That's just sort of reverse moral hazard, if you want. That like something I could be liable for something I don't know whether I'm going to be, but I could be, and there's no insurance to cover me if I am. Well, maybe I better go a little more slowly. And that seems to me actually to be a good thing in this case because the technology is evolving very fast. The psychology of how people interact with it is very little understood. And these could be very harmful developments. And we're seeming to proceed at a breakneck pace to just rush things to market. And so maybe this is all actually a really good thing. Like we ought to restrict insurance. We ought to make companies maximally uncertain about whether they're going to be liable and for what, just so that they go a little bit slower. So the rest of us, maybe this is just an old person speaking, it's like we have to figure out what the heck is going on here. And the technology moves so fast, we might do better with this uncertainty that you seem to suggest is a problem. I say we could possibly see it as a benefit. So I'm curious to know how you react to that. The other thing is a lot of these AI companies are very, very large. I mean, I just looked up, Anthropic's market cap is something like 350 billion. Nobody knows how much TikTok is worth since it seems to have been sold in a corrupt sale, but 300 billion, there's like a 300 to 500 billion. It's like those guys don't even really need insurance. Whatever they're liable for, they're going to be able to just pay anyway. So I don't know.
Yeah.
Just curious to get your reaction to that. That wasn't really a question. That was just a like, what do you think?
Yes, Peter, I love that. I love both of your questions. The first question, I think it depends on who you're asking, right? You're asking me, but like you're depending on it depends on whose perspective you might be interested in. And I think it is, a separate but really important question, which I think is what you're asking, which is a normative question of should we have insurance to protect against these kinds of harms, which would lead to all of the things that we've discussed. And I think that's an important question, but I do think it's a different question. And I think it's a question that focuses its attention on consumers, on users, versus its attention on innovation and firms. And perhaps that's where regulation comes in, actual regulation. I won't hold my breath as to when that will occur. I'm teaching an AI and law class right now, so I'm thinking through these issues quite a bit domestically. But arguably, you might say that's where we might look to the state and government to create other either ex ante or ex post. Well, I guess we're seeing the ex post, develop, but maybe more ex ante legislation and regulation to deal with some of the issues that we're seeing. So I think it's a really good question, and but yeah, just a separate question. And I'm not trying to not answer it either because I think it's a really valid one. Whether we should be encouraging, these types of businesses. I think at this point, my perspective is, the train has left the station. The tools are being used. And insurance doesn't presently exist. And on the other side, there are benefits that we can certainly and are obtaining from innovation within the AI space. And then going to your second point on, yes, the valuation, the immense amount of resources that these firms have. Absolutely. And, I really am focused on these smaller firms. So I'm thinking of AI startups. And, every large business started as a small business, was a startup. Um, and we don't know where the next big innovation will come from. And so I do think it's important that we think about smaller firms, smaller startups that might be encouraged or discouraged from entering into this space. And I think we have some reason to be concerned about these smaller businesses. I mean, we see with DeepSeek, there are small, lower resource firms that are utilizing this technology and growing the technology in ways that are much less expensive, and are in some ways competing with the largest companies. And so I think there is something to be said for small startups and not knowing where the next big piece of innovation that perhaps we're not even aware of might come from, and how that might benefit society more broadly.
Thanks.
Great. So we'll see if we have one more question, but while we're waiting, I am going to paste into the chat the form for anyone who's interested in getting CLE credit in Connecticut for the session. So we have about 2 minutes left. Dan.
Well, I can't help but ask more questions because it's such a great paper and interesting project. So I have 2 more questions, Renee. So question 1 is about the prospect that one reason potentially you might see firms reluctant to buy this insurance is the fear that that actually could indirectly cause courts to be more willing to find liability. So, especially for these smaller actors, it may be that it's a much better strategy for them. And even if insurers offered it coverage, they might think, hey, why buy the insurance? So I'm assuming if I don't have insurance, I'm less likely to get sued. And if I do get sued, a court might be more hesitant to impose massive amounts of liability because that would mean, my destruction. Uh, my second question, and this is relates a bit to Peter's question, marries Peter's question. My initial question is, one of the instincts of the paper is that we want an insurance market in part to ensure that there's, a robust market competition in AI. And to me, that's a much stronger argument when it comes to chatbots, which you mentioned there are huge upsides as well as downside risks. And it's hard to cabin off some of the risks that you're talking about from all the great things that chatbots do as their general purpose versus frankly I don't know that we get any social value from encouraging competition in algorithmic recommendation from social media platforms. I'm kind of perfectly fine stalling out competition there. It's not clear to me if one of the sort of motivations of the paper is, gee, we need insurance to preserve competition and promote innovation, if that's a very powerful argument in that domain, which I guess goes back to my, earlier question about conceptually breaking apart the social media piece of algorithmic liability that you're discussing in the chatbot piece.
Right. Yeah, excellent questions. I think I guess I'll your last question in the last little bit here. Yeah, I guess I am compelled by technology firms that started as one thing and have turned into something else, right? So we have Facebook, which used to be something much smaller, much more different than it is. So I guess that's just to say we just don't know where innovations will come from, and I think it's very difficult to predict where potentially beneficial uses and technologies will come from. So So yeah, I guess, but I need to think through that a bit more. And then to your first point, I agree that yeah, it's certainly sound that if firms purchase insurance, ultimately, that may mean that courts may or are more likely to find against them. I guess I wonder how firms think about that and whether they think as explicitly about that when they are endeavoring to purchase insurance. But I don't disagree with your base argument there. So I'll stop talking there. I know we're over time, but thank you so much, Dan.
Well, thank you, Renee. Great way to kick off the semester. Fantastic paper, and we look forward to seeing you all in 2 weeks for Esserhan Esser's paper. So see you then.
Thank you.